Hey, I'm Creed with Homebuyer University. Today we're going to talk about the seller's property disclosure, the inspection objection form, and the inspection resolution form. So it's gonna take us a little bit to get through this, but we're going to be fine. Let's get rolling. This is the seller's property disclosure form, and this is for Colorado. And as always, this has been approved by the Colorado Real Estate Commission, and you should consult legal and tax counsel before signing this. So the seller's property disclosure, what is that? You've gone under contract with the seller on a property that you'd like to own, and they're going to present this to you, your agent, and tell you what they know about the property. If they know stuff that's important that is not mentioned on this form, they're supposed to add that in, okay? If you have something that's really important to you, vital to you, you don't want a home, if this condition exists or this condition doesn't exist, right? If there's something specific, you should probably, and this is not legal advice, we all know we don't do that here, but you should probably build that specifically in when you sign the exclusive right to buy contract when you hire your broker. That was in prior courses, so if you don't remember, go back and take a look. But there's a spot there for additional provisions. In other words, if you state that I've got to have a property with X, this quality, and it might be part of the land, it might be part of the HOA, it might be part of the house itself, right? Go ahead and build that in there. Otherwise, this covers as much stuff as the Colorado Real Estate Commission could think about. So as always, I'm going to try to be as thorough as I can. My goal is not to make you suffer through long videos, but I think that after seeing 3, 4, 5 of the courses already, you're starting to really understand how complex this stuff is. And if you were to wait till the last minute when you're trying to work a deal and trying to understand all this and put up with all the stress and confusion of the negotiations, it might just take you over the edge. So we're trying to get you knowledgeable about what's going to happen. So when it happens in real life, when you go from virtual home search to real life home purchase, you're ready. And I'll edit out as much as I can. Okay. The seller's property disclosure, let's just read right into it. Seller states that the information contained in this seller's property disclosure, SPD, is correct to seller's actual knowledge. And what that means is they are not going to go out and do an inspection. They are giving you what they know about the home based on having lived there. You're the one that's going to get the inspector, okay? Changes must be disclosed by seller to buyer promptly after discovery. What that means is on the date you do this, if something were to change, an adverse material fact, and we're going to try to talk about that so you get an idea of what that means. After the seller has filled this out and sent it to you, and even after you've done your inspection, if something else happens, they're supposed to inform you in writing. Always do everything in writing, okay? If the sales contract requires seller to complete this SPD, seller's property disclosure, this form must be fully completed to seller's actual knowledge. What's that mean? If the sales contract requires, well, let's jump back a little bit and let's take a look at our sales contract. Remember this? Was this course number 3, the sales contract? I think so. Contract to buy and sell real estate. As always, approved by the Colorado Real Estate Commission. As always, consult legal and tax advice, okay? Let's roll down here. Remember the grid section with dates? These were all the contingencies, all the things that you needed to complete by a specific date and time, which would normally be right over here. If you don't complete them by a specific date and time, that means you are waiving your right. So let's go right down to the seller's property disclosure right now, and let's highlight this for you. Seller's disclosures. Seller property disclosure deadline. So in the seller's property disclosure, along with all the items on your grid here, on your contract, your purchase contract, you're going to have a date and time that says you should have received this by this date and time, ideally well before your inspection, and it gives you a heads up if you need to order any special inspections. So if the seller says, yeah, we get a little water in the basement every other day, you want to have a specialist come in. Your general home inspector is not going to be able to handle that, okay? What happens if this thing is blank? This is how it's tied in. Remember that seller's property disclosure said if it's part of this contract. This is how you make it a part of it. This has to be a specific date and time, and then it ties this into that. Same thing for the inspection objection date, which is in here, okay? What happens if that's blank? Do you remember what happens if that's blank? Let's remember now. Applicability of terms. If it's left blank or completed NA or the word deleted, such deadline is non-applicable. What that means is if there's no date or those two terms, NA or none or deleted, okay, that means that's not part of this contract. A lot of buyers were doing that when the market was overheated, and they waived the right to do their inspection. And nowadays, I suggest you never do that. In fact, I still suggest you never do that. And they waived the right to a seller's property disclosure. And you probably don't want to do that either. You want to know what the prior owner, current owner, soon to be prior owner, if it all works out, knows about the property. Okay, so you fully understand how the seller's property disclosure ties into your main purchase contract. So let's go over to the seller's property disclosure and run through this. So let's go ahead and figure out what an adverse material fact is. And we're going to take a look at the broker's required disclosures. And this is what they call, let's see if we can get that to pop open again, Commission Position 27, Broker Disclosure of Adverse Material Facts. What is that? The Colorado Real Estate Commission, part of the Department of Regulatory Agencies, oversees all the real estate brokers. And they get to tell them what to do. They're the boss of the real estate brokers. They don't get to tell you what to do, because that would be practicing law. So sellers and buyers can do what they want within the covenants of all the contracts and addendums and disclosures they sign. The Colorado Real Estate Commission can't tell you what specifically to do, but they can tell we brokers, whatever, what to do. So let's look at what they tell the brokers to do. In all real estate transactions, brokers are obligated to disclose known adverse material facts. We're still going to cover this, I promise. So if the seller mentioned sometime weeks back that they get water in the basement and they forgot to put it on the seller's disclosure, now that the broker knows it, they are required to disclose it. Works both ways. With the broker working with you, the buyer, if they know for sure that you have no chance of ever qualifying for that loan, they have to disclose that. Makes sense? So it works both ways. What is an adverse material fact? Now we're starting to get somewhere. Let's look and see how the Real Estate Commission defines that on behalf of brokers, or at least guides them. To answer these types of questions, brokers should initially consider whether the information is material. Factual information is material when a reasonable person would ascribe actual significance to the information. Is that all clear for you? That'll be on the final exam. If it's important to somebody in the transaction, you, then it's material. So we've gotten that far. Factual, of course, means it actually does exist. It's not made up. And they're going to give us some examples of material facts here, including facts affecting title, facts affecting the physical condition of the property, and environmental hazards affecting the property. These are just examples. That is not an all-inclusive list. So thinking back to the seller's property disclosure, the Real Estate Commission's done everything they could think of, put it in that form, and then there's some blank areas for the seller to add stuff if they know of something that the Real Estate Commission didn't think of. But going back to you hiring a broker to work on your behalf as a buyer's agent, not a transaction broker, not a customer, buyer's agent. You can put in the additional provisions if you wish, and this isn't law advice, right, that you want them to investigate on your behalf. So let's take another little bit of information here and see how they further define this for the brokers. Next, brokers should consider whether the material information, what makes it material? If it's important to you, is adverse to a party's interest in the transaction. They suggest looking at Black's Law Dictionary, 11th edition, 2019, defining the word adverse. Is this adverse to someone, you? Well, what? They want us to go find a law dictionary. Nobody's going to do that, right? I did. Hang in there. Let's pull this thing up. So, here's Black's Law Dictionary. And apparently it looks a whole lot like this. And for $85, I can have one. And 45-day returns. They figure if you're going to get your law degree, it's going to take you longer than 45 days. It looks pretty big and thick, and I didn't know that I would have to look this up for today's video until today. And so what we did are these folks here at the lawdictionary.org saying they're using the information from this Black's Law Dictionary to help us out with stuff. So let's find out. The Real Estate Commission told us to go look up the term adverse here in this dictionary. Let's go take a look and see what these guys think. Aha! Search results for adverse. Adverse possession, a lot of this is irrelevant to you at this time. Squatters' rights, no. How about this one? This looks pretty good. Adverse interest. Any interest that will completely or partially displace your own interest in something. These attorneys, they have all the fun, don't they? All right, let's try to break this down. Your interest in something, what do you think that might be? The house and anything that affects it. Fair enough? That's not legal advice, right? Any interest that will completely or partially displace your own interest in something. So if there's something about the property, title, physical condition of the property, anything that affects the property, that would cause you to partially or completely no longer desire that property, that means it's adverse. And that's not the super clean definition we would all love to see, but that gives you a pretty good idea. If it would ruin your desire for the home, it is an adverse condition. Sound fair enough? While we're here, we're going to take a quick glance and see if the Colorado Department of Regulatory Agencies Division of Real Estate, Colorado Real Estate Commission, has anything more to tell us. It says, and by the way, this is now 2 years old, and you have to be careful. These contracts and disclosures and everything change a lot from year to year. And just to show you, somewhere in here, I remember it saying on the last page of the document, page 8, it's already up to 10 pages now, so it changes a lot. Seller's property disclosure is important for the real estate broker to discuss with their respective client. By the way, we're doing that now before you're trying to negotiate your deal. And they're just letting you know it's a really important form. And this is actually already something we've covered. You don't need to see all three of these. You're dealing with the residential properties. And best practices. This is, again, the Real Estate Commission telling the brokers how to be good and nice. Best practices, brokers should not take a hands-off attitude. Neither should you. Both of us need to dig into that form as best we can, okay? Review it. Having reviewed the property, if there's anything contradictory in there, you need to figure it out, and we need to talk about it. And the rest of this is pretty much common sense. We'll go ahead and jump back to our forms. So we've covered, this is again the commission statement, essentially the Real Estate Commission telling brokers how to deal with disclosures. And we've lived through all this stuff. And I think we have a really good idea now on what a adverse condition is and why it's important to you. Actually, if it's important to you, it is an adverse condition. And it mentions here a few things. It could be anything that affects the structural integrity, health risk, environmental hazards. But that's not a complete list, right? We've just covered all that. So we'll get this wrapped up on the position statement. Brokers have to disclose if they're aware of an adverse material fact, but there are certain things that brokers are actually not allowed to disclose, and you should be aware of them because they might give you the creeps a little bit if you read into this. Brokers must not disclose circumstances that may psychologically impact or stigmatize real property. Real property is a structure attached to earth, real estate. We are specifically not allowed to disclose HIV if anyone in the home's ever had it, and if the property was the site of a homicide or other felony or a suicide. And so just be aware, there's stuff that actually we're not allowed to talk about because it could stigmatize or harm the value of that property. So let's roll back now. We've touched on all that stuff and we're getting a really good grasp. Let's shoot through the seller's property disclosure. Let me roll up to the top. And we're going to do this as quickly as we can and wrap this up. Let's just run through this. And what you'll see is there are sections that are related. Building conditions, roof, appliances. And it's a long form. It's 10 pages now. And the prior disclosure, that commission position statement, mentioned 8 pages, so it's grown 2 pages since then. And there's just a couple of major things I want you to understand on this. If you know, not you, the seller, if the seller knows of any of the following problems ever existing, check yes. That would be this. Okay? And ideally, if they check yes, they're going to give us some explanation and some details and some context. And you'll want to get all this before your inspection because a structural issue would be something separate from your general inspection. If it ever existed. So what that means is if 2 owners back, right, let's say 25 years in the past, had a structural problem and one of them corrected it and everybody going forward knew that correction, that repair had been made, they would still report it to you if it made it that far up. Ever existed. Let's scroll down. Roof. If any of the problems ever existed, check yes, give us the background. They can attach additional documents. Appliances. Now existed. So there's 2 different separate terms that they use here. And if you think about it, it makes perfect sense. Building, structural conditions, real important stuff. If they know about it ever existing, tell you. Roof, pretty important stuff. If it ever existed. Appliances, if they're built into the contract and you get them and the sellers are leaving them. Yeah, it is important, but is the disposal as important as your foundation? Probably not. Do you need to know about 4 disposal replacements back in the past in the 1950s? Probably not. Did they have disposals in the 50s? I don't know. And I've been at this a long time, but not that long. And so we're not going to go into every paragraph here. Yes, it happened. I know about it. They might tell you if it's a new system or a couple years old and give you context and information. And this goes on, and you can see how comprehensive this is. So the Real Estate Commission tried to build in everything they could think of, but if there's something really important to you, get it built into the additional, no, you know what, it wouldn't even go into the additional provisions. It would go into the due diligence paragraph of your contract to buy and sell real estate. Say, I'm going to specifically look at this. Or if you have information about this, give it to me. And your broker will explain that in more detail. But you can see they tried to cover everything. I know it's exciting to watch this thing scroll down, but it's a big form and you got to go through it. Aren't you glad you're figuring this out ahead of time? You don't want to have to try to figure out what an adverse material fact is on the night you're making an offer. Jeez, you don't need that. Seller and buyer understand that real estate brokers do not warrant or guarantee this information. Seller gave it to the broker, broker gave it to the other broker, broker gave it to you. That's about all they know about it. If they know something else that's not on there that is a true adverse material fact, they will tell you, but they don't warrant or guarantee anything. They advise the seller to be truthful and honest and give full disclosure based on their current actual knowledge. In other words, if they've never been in the attic and there's some sort of water-based fungus growing in the attic, they can't disclose it if they don't know because they never went up there. Thus, you did your inspection. And they're also telling you that you should go ahead and confirm and inspect and check into anything that's important to you, anything and everything. They like to reiterate this is seller's current knowledge. If you have any really big concerns about the lot, fences, outbuildings, survey or improvement location certificate is probably going to be the tool you use. Your general home inspector, they're not going to know about lot lines. And at the end of all this, right, you've made hundreds of decisions when you're writing all these contracts and addendums and counteroffers and dealing with inspections and notifications, right? Once it's all said and done and you get there to the day of closing and you sign the documents, all of your decisions are now a permanent part of a series of documents that you've signed your life away on, and you've purchased the property as is. You had your chance to see if there were any problems, and you now own it in its current condition, and you've been made aware of it. And that is it. We're going to now really quickly go into inspections, inspection objection, and inspection resolution because they're so tied into this, it only makes sense. Okay, we're going to quickly jump back here to the contract to buy and sell real estate. You're seeing this a lot, but it's really important that you really understand this thing. We're going to scroll down to our dates and deadlines. This is that grid pattern that we've seen so often, and you're really starting to get an idea how important it is. We just talked about the seller's property disclosure right here. You would have received that by a specific date and time and instantly began reviewing it and preparing any inspections you want to do based on the information in there and whatever else is most important to you. It has to be to you by this deadline, or there's specific actions you must take if you do not have it by this deadline. Okay? Same way with all this stuff. You have to send a notice to the seller of your disapproval of things, and we won't go into that right now. This is already long enough. Tied to this, very much tied to this, are your inspection criteria. And let's talk about this first one. Inspection termination deadline. In most cases, now you can use it a different way, but in most cases, what that means is it's a go, no-go situation for you. Seller says, you know what, I don't care what you do, I'm not fixing a thing. Sometimes they start real tough like that, and sometimes they soften up when they're about to lose out on the deal. But if you're going to use the inspection and state, I'm either buying it completely as is or not buying it at all, that's the proper way of using this, okay? If you're going into it with a different mindset and based on your inspection, so you've seen the seller's disclosure, you've inspected, done a general home inspection, and maybe done some specific home inspections, foundation, roof, heating, plumbing, electrical. Those are all kind of separate specialty items. If you have some problems you've come across and you want to try to work out a deal with the seller to get this stuff fixed, you would do an inspection objection deadline by when? By the specific date and time you put in here. Everything has to do with those dates and times. If this says January 2nd and you don't send it over till January 3rd, what does that mean? It doesn't really exist. On January 2nd, at the end of the day, you waived your right to object, okay? And so you send over the bad news to the seller and say, dear seller, we'd sure like to get this fixed. And the seller and you will work out some stuff, hopefully. And if you can work out stuff, you're going to put the final resolution to this into a separate form, inspection resolution deadline. And when are you going to do that by? At least by or before the date and time in here. And if you can work out stuff and everybody's happy, you attach that to the original contract and the seller goes to work getting things done. Make sense? But let's look at those two forms real quick. The first form is that inspection objection notice by the inspection objection deadline and approved by Colorado Real Estate Commission. Get tax and legal advice. And it's going to talk about the property. And you're going to say what your problems are. You're going to say, this is what I want you to do. And it doesn't mean you'll get it, okay? You'll get that when you get the inspection resolution document all hammered out, and we'll talk about that next. Let's look at a couple notes. Resolution of inspection or other items agreed to by the parties may alter the terms of the contract, and require disclosure by buyer to buyer's lender. What? Why? What? You're not even sure you like that lady. Let's say we've got a structural issue. This is just an example. And there's a crack. And you know it's there. And you heard it can be filled with a special epoxy mix and so on and so forth. And the seller said, listen, I'll float you $20,000 at closing and we're done. You think, well, that's pretty good because maybe I can get this fixed for $5,000 and yeah, cool. Well, your lender's probably not going to like that because you're getting money from the seller and it could screw up your loan. So be careful what you negotiate with, what you come out with, and be aware that if it affects the loan, you could be starting all over there, and that could put you in default on the contract and dates. And just be careful on that, okay? If buyer and seller have not agreed in writing to a settlement on the above matters on or before the inspection resolution deadline, the contract will terminate, okay? Unless you send something to the seller that says, you know what, never mind, I withdraw all my requests. So this would automatically terminate because you sent over, you sent over the objection. And if you can't reach a resolution, and we'll talk about that in a minute, then this is going to expire automatically. Make sense? So let's jump over right now to the inspection resolution. You got the seller disclosure. You made all of your inspections, general or specific. You sent over an inspection objection notice by what? The date in the contract. And you and the seller are now working out everything. You might kind of discuss it a little bit verbally. I know verbal's scary. That's why we're going to put it in writing. And once you've worked out all the details on who's going to do what, by when, and for how much, you're going to put that in here. And as always, approved by the Colorado Real Estate Commission. Legal and tax advice, please. Inspection resolution. Amendment to contract to buy and sell. This is the thing that gets attached directly to your contract if you get this all worked out. And they talk about a little bit here what the contract is. Here's your resolution. And you don't have to talk in big, fancy, fluffy legal language, but you want to spell out very specifically. Seller will replace the horizontal supports on the rear deck with pressure-treated lumber 2x8s at the cost of X by such and such date, that sort of thing. And not legal advice, but that's really what you need to put in there. Be specific. This document amends the contract, and thus it's going to go to your lender. And what did we already talk about? If you do something that's going to get you some money back or might change something on the terms, or, right, if you find out there is a crack in the foundation, and even if you're not going to get money back, it might make the lender quite nervous because now they're like, well, is this house still worth the $572,000 appraisal, or is it now worth $550,000? Well, lenders want to know that stuff, so be careful. That's all I'm saying. Be careful. And that's it. We finally got to wrap that up. Seller disclosure, general inspection, specialty inspections, which might be foundation, heating, plumbing, that sort of thing, roof. If you have a problem, inspection objection by the deadline, and then you try to work out all the details and put it into the inspection resolution document, and that attaches to the contract, and you want to make sure that doesn't mess with your loan, and you're done. You've made it through this course. Good job. Thanks.